I'm Melvin Raymond, attorney and counselor at law. Welcome to Raymond Law Live. Do you know what would happen to your property when you're gone? Do you know who would be entitled to your property when you're gone? This is a matter that you may have thought about, or maybe you haven't thought about it. Maybe you've thought some about it. Maybe you haven't thought anything about it. Well, this is an important topic. If you don't do any planning about what happens to your estate when you're gone, then this is what may happen. You will lose the right to choose what happens to your estate, and in particular, you will lose the right to decide the distribution of your estate to those who are entitled to distribution of your property. So it's very important, and if you get nothing else from this broadcast, you need to know that you should plan. Planning is very important, and thinking ahead and planning. So I want to make that point if you get nothing else from this broadcast. Now, there is a process for transferring property after you're gone or at the time of your death, and that process is called probate. And that is the topic of today's broadcast, probate. I do want to mention, I invite you to use our new feature called What's Your Need? This will give you the opportunity to tell us what topics you want us to cover in future broadcasts. You can do that by contacting us, sending us an email, or posting that. Our email address is mraymondattorney@sbcglobal.net, or you can post on our Facebook. That's facebook.com/RaymondLawLive. Just send us your topic of choice and we'll cover that topic in a future broadcast. So let us hear from you. The other thing is, during the course of the broadcast, we are taking questions, your questions and comments. You can post your questions on our Facebook page. That's Raymond Law. That's facebook.com/RaymondLawLive. So send us your questions or your comments about our topic today, which is probate law, and you. Now let's get on with our topic. Now, probate does come into play when whatever property that you own at the time of your death. Now, that comes into play if you have not arranged or made any arrangements during your lifetime for distribution of your property, whatever it is, at the time of your death. Now, probate, it doesn't depend on how much property that you have. You don't have to be a millionaire for probate to apply to your situation. It's whether or not, it's not how much property that you have, but it's whether or not you have any properties. So it doesn't matter if you have $1 million or how large your estate is. In my practice, I have handled estates that consisted of just one or two things. It could just be a car. And you may think that, oh, I don't have nothing, so I don't need to worry about probate. Well, that's not true. I think that, again, planning ahead and making some arrangement for distribution of your property such that it is a way to avoid probate. Now, it does happen that you can, we'll discuss in a minute the way to avoid probate. But it does happen that you can also plan ahead to have your estate probated. And if you plan to have your estate probated at the time of your death or immediately thereafter, then you can do that with a will. And a will, of course, takes effect upon your death. And we've discussed wills in prior broadcasts. So that's one way that you plan for probate. And for some folks, and it depends on your desire, they do want to handle things of their estate after they're gone through a will. and that's a way that you intentionally plan for probate. Now, let me talk a moment about avoiding probate. There are things you can plan ahead to do if you want to avoid probate. Some people do not want to go into the probate process, so if that's the case, then there are things you can do to avoid probate so that it doesn't come into play. Now, what can you do if it is your desire to dispose or transfer your property to those who are entitled to receive distribution of your property? What can you do to avoid that and make sure that the transfer will occur to those entitled to distribution without probate? The first thing you can do is to jointly title property. In that case, the property will be transferred by operation of law to the surviving joint owner. This happens sometimes with bank accounts as well as other kinds of accounts, including, for instance, IRA accounts, investment accounts, bonds, and so forth. So, titling property jointly. That also applies to real estate. You can, there's a couple of ways you can do that, but you can add someone's name as a co-owner to your real estate. And in that case, as with other joint accounts or joint property, upon the death of one of you or one of the other owners, then the property, by operation of law, becomes owned by the other surviving joint tenants. Now, there are, with real estate, different forms of joint tenancy. So if you're thinking about doing that, then you should consult with an attorney, because there's different ways of doing that. One is through a joint tenancy on real estate. Another is with what we call in Missouri a beneficiary deed. A beneficiary deed is a special kind of deed that you can prepare and file with the recorder of deeds in the county where the real estate is located while you're living, and that would not take effect until your death. And let's say you prepare a beneficiary deed deeding some real estate to a beneficiary, any person that you identify, a person of your choice, and you decide to change your mind, then you can simply revoke the beneficiary deed in favor of wherever you selected at first and do another beneficiary deed, and that'll have the effect of revoking the first beneficiary deed. So that is the kind of thing that you would want to consult an attorney with if you're considering jointly titling property or doing a beneficiary deed to avoid probate. There are other ways you can avoid probate, and the second way is through a POD designation, pay on death designation. Again, that would of course take effect upon your death. That is usually associated with any kind of accounts such as bank accounts or IRAs or other kinds of accounts, pay on death. And you do have to go to the depository institution or obtain from the depository institution the document to designate to pay on death. And what happens is, at the time of your death or soon thereafter, the account, by operation of law, is paid to the person whom you designate that it should be paid upon your death. And a third way, as far as dealing with property to avoid probate, is transfer on death, TOD. You can do that by simply, applies to cars, automobiles, any kind of vehicle. That applies, transfer on death. And that means, as with a pay on death, as with accounts, bank accounts and so forth, TOD means that a transfer on death to whoever you designate. So you will have to obtain from in Missouri, it's the Department of Revenue, a transfer on death form. You complete that and identify and designate whoever you want to transfer the property to upon your death. You name that person, and a new title will be issued, and it'll be endorsed with let's say, your name, and it'll indicate on the face of the title a pay on death to whoever you designate to receive or to have the property transferred to after your death. So those are three ways you can retitle property, or at least deal with property, by planning ahead. And again, those are jointly titling the property, real estate and so forth, and POD, as with accounts, PODs as designations, or TOD designations. Now let's get back to when probate may apply if you do not plan ahead and as to the transfer of your estate upon your death. So what happens when the owner of property dies without making any plan for distribution of his or her estate? In that case, your estate will be distributed in accordance with the probate laws. And the law that we're talking about here is called the law of intestate succession. I'll try not to get too technical, but that's the probate law that applies when no arrangements have been made for distribution of the estate during your lifetime. Now, property, once you're gone, then your property doesn't automatically go to it would be your heirs at law. That does not happen automatically. So you have to go through the probate process, and that's a process for actually transferring the property. So it doesn't happen automatically. So you just can't become a legal owner of any property of a deceased owner unless you go through the probate process, unless the person, as we said before, have made arrangements and planned ahead to handle transfers after they're gone. So who's entitled to receive a deceased owner's property in the case where there's been no arrangements to distribute or transfer the property? Well, it would be the legal heirs, and there's the first class of the persons who are entitled to receive a deceased person's property if there's no other disposition is, of course, the surviving spouse. And the second class would be the children. And I'm talking about lineal descendants or biological children. So if a deceased owner has a surviving spouse, then the surviving spouse would inherit a portion of the estate along with all of the surviving children who are biological children or legally adopted children. They would share in the estate with the surviving spouse getting a portion. Her portion would be, or his portion would be a half, and then the other half would go to the surviving children in equal shares. So the estate would be evenly divided between all the surviving children. Stepchildren are not lineal descendants, so they would not be entitled to receive a distribution of the estate. Stepchildren, for purposes of probate, they are not part of the legal heirs, of the class of legal heirs. So that's very important. Some people think that their spouse's children automatically inherit their estate, but that isn't true unless the stepchildren are adopted. So I'm talking about the legally adopted. So stepchildren do not inherit the property of a deceased owner. So, what happens when the deceased owner has no surviving spouse and no surviving biological or adopted children? Who is entitled in that instance to receive distribution of the estate? Well, the probate law provides for other classes of persons who are called collateral heirs who would take in the absence of a surviving spouse or surviving children. And the next class after surviving spouse and after children, the third class of persons who are entitled to receive a deceased person's estate is the surviving parents of the deceased. If there are surviving parents, either one or both surviving parents. If there are no surviving parents of the deceased owner, then the next class, which would be the fourth class, would be what we call collateral heirs. And they would be the siblings, the surviving siblings of the deceased owner. They would share the estate equally. Now, if the deceased owner has no surviving spouse or biological or adopted children or parents, the next class, the deceased, the surviving siblings, if there are siblings who predeceased and did not survive the owner, then that doesn't mean that all the other siblings would get the share that the predeceased sibling would have gotten. What happens is the predeceased brother or sister, their children, if any, or heirs, if any, would only be lineal descendants. Their heirs, children, would receive the portion that the predeceased sibling would have received. So let's say owner has 3 surviving siblings and 1 predeceased sibling who has, let's say, 2 children, biological children or adopted children. Then the 3 surviving siblings would share in the estate. They would each get, and also the share, the surviving children of the predeceased sibling would share that portion of the estate. So if it's 4, let's say 3 surviving siblings and 1 predeceased sibling, then the estate would be divided 4 ways instead of 3, meaning that the 2 children of the predeceased sibling would receive the share of the deceased, the 1/4 share of the predeceased sibling. So the estate would be divided in 4ths instead of 3rds, and the children of the predeceased sibling would get their 1/4 share of that would have been taken by their predeceased parent. So that's down what happens if there's in terms of who is entitled to distribution of a deceased person's estate. There are different classes, and you have 1, 2, 3, 4, 5. So 1 is, of course, the surviving spouse and the children. The 2nd would be the parents, and then the 3rd would be the siblings, and so forth. So that's generally how the heirship goes if the owner, the deceased owner, does not make any arrangements for the distribution of their estate during their lifetime. Now, sometimes people talk about what happens if no heirs are identified. All those 3 or 4 classes of heirs I mentioned, what happens if the owner of property, the deceased owner, has no heirs, or no heirs can be identified? Now, that happens probably more than you would think. So people talk about, well, if no heirs can be identified, then the property goes to the state. That's true. If there are no heirs anywhere, either the spouse or children or siblings or parents, nieces, nephews, cousins. Sometimes it gets down to cousins, first cousins, second cousins, and so forth. That does happen. So in that instance, when there are no identified heirs, then your property would go, the unclaimed property that is, would go to the state. And in the state of Missouri, it would go to the state treasurer, to the unclaimed property division. Our state treasurer in the state of Missouri has an unclaimed property division, and they have a website for unclaimed property. It's www.showmemoney.com. www.showmemoney.com. Don't forget to post your questions or comments, and we'll get to them. So, if you think that someone may have left you some property that's been unclaimed, then I would suggest that you go to, in Missouri, if you live in Missouri, or you have someone who is deceased who lived in Missouri, it doesn't hurt, phone call or just go on the website to www.showmemoney.com. You may be surprised. So if you think there's somebody left you some property and it's not claimed by anybody, then just go to the website for the state treasurer in the state of Missouri. And I would think that other states have some way to provide for checking to see if there's any property that heirs that's been left to heirs that remains unclaimed. I have a question. How would the designation be handled if there is a minor and that person is entitled to receive the designated property? Now, for purposes of that's a good question. When the heir is a minor, and that could be a beneficiary under a will, or if there is no will. So what happens if the minor is the beneficiary of the estate, in that instance, or a portion of the estate for that matter? In that instance, now for purposes of probate, a minor is an individual under the age of 18. So anyone under the age of 18 for purposes of probate is considered a minor. If the person is under 18, then the probate court will not distribute the estate to a person under the age of 18. The distribution will occur after the beneficiary, who is a minor, turns 18. The day they would turn 18, what happens is the court would distribute the property to a guardian, a conservator of the minor. You would have to find a conservator of the minor, and usually that is a parent or the minor's next of kin, a parent, mother or father. If they're around, then they would appoint one of them to be conservator of whatever the minor is inheriting, and the conservator would have to hold the property until the minor reaches the age of 18. Now, the probate court is very strict about conservatorships, and if a minor under the age of 18 inherits property, then the parent or whoever is appointed as guardian cannot use that money for themselves or have access to the money for themselves. Because if you do, then the probate court could surcharge you and hold you accountable. That money is to be held for the minors. In my practice, I have had instances where the beneficiary of an insurance policy was a person who was a minor under 18, and the insurance companies will not pay the proceeds of life insurance policy or any other insurance policy to a minor, a person under 18. The insurance company or whoever the payer is will require that the minor obtain a court-appointed conservator to hold the proceeds of the insurance policy for the minor, and then once the minor becomes 18, then the minor the property is distributed to the minor, and it cannot happen before the minor gets to be reaches the age of 18. So we're getting to the end of our discussion for the topic today. Now, you may be wondering what happens, what is the actual process, the probate process, once the person who are entitled to receive distribution of their estate, once they are gone, then how does the actual probate process work? Well, that will be the topic for the next broadcast on March the 20, I think it's March the 26th, Tuesday, March 26th. So join us for our next broadcast on Tuesday, March 26th. You can send us your. I want to thank all of you who are watching this broadcast live, and those of you who will be watching the broadcast later. You can reach us at my email address. That's mraymondattorney@sbcglobal.net, or you can reach us on Facebook. That's facebook.com/Raymond Law Live, or Twitter at Raymond Law Live, or you can call us at area code 314-534-2800. Thank you all for listening. Join us for the next broadcast on Tuesday, March 26th at 6 p.m. Central Time. And remember, when you fight, know your rights.